Thanks for joining us again at Consumer Trial Lawyer Academy. I'm Nick Wooten. Started this YouTube channel, as we've said before, to try to give those of you who are in the trial lawyer community, the consumer trial lawyer community, who have not tried a lot of cases, the benefits of, my missteps and my lessons learned and my experience, hopefully allowing you to replicate or even exceed the type of success that I've been fortunate to have in the courtroom, and to equip you with primarily the confidence that you have done your work to go in and present your case effectively and be successful, and hopefully answer any questions you might have about the process and what you can expect in the courtroom so that you can be successful as you go forward. Today we're talking about the direct examination of witnesses. Again, we typically are talking about the perspective from trying a case in federal court in front of a jury, with all the pomp and circumstance that goes along with that, to demystify that process so you can have a sense of what you're walking into. And again, hopefully to give you more comfort and confidence so that you can go and do it yourself and become a successful trial lawyer in your own right, or improve the results if you're already trying cases. So when we talk about directed witnesses, as the plaintiff at trial, we have the burden of proof. You remember from prior videos, we always start with the wrongdoing, corporate defendant, corporate America, and we work our way towards from the wrongdoing, the destruction, the wrongdoing that's over here all the way to the destruction of our client's life, the beginning and the end, so to speak. And so we're calling, what is in essence hostile witnesses on direct exam. And, we have to get what we need from them, and we have to do it in a way that we don't mistreat them. It's the interesting part about it. You can never let your own emotions enter into it. You can never be emotional. You can never get angry, yell, scream, pound the table, lose it, whatever you're going to call it. You always have to be polite. You can be firm, but you always have to be polite, because your job is to get the testimony in front of the jury. It's not to abuse anybody or put them on the rack because they're at trial. Treat them as if you would want your own loved one to be treated if they were being questioned by someone in that type of setting. You would not want someone to badger them, harass them, abuse them, mistreat them. And I think we talked about this in depositions, but the philosophy over time, by learning empathy and by, putting myself in the other person's position, realizing for them it's just a job. They're being forced to be there. They don't really want to be there. Most of the time they're not what I call a corporate true believer. They're doing a job and they're worried about, if I do it wrong, am I going to lose my job? That sort of thing. My philosophy and my practice developed over time. When I was younger, lacked empathy, less understanding. The way I approached these things was I ran up to the witness, I grabbed him, picked him up over my head, ran to the cliff, and threw him off the cliff. Proverbially, of course, not in actuality. And so that was very violent, that was very attacking, that was not often very considerate. But I won, right? So they say. And so now the philosophy is more like, dear Mr. Witness or Mrs. Witness, here's this cliff. Would you walk over to the edge of this cliff and look and confirm for me and the jury that this is in fact a cliff? And now that you've confirmed that this is in fact a cliff, Mr. and Miss Witness, what I would like for you to do is take about 5 steps out off the edge of the cliff until you're far enough away from the edge that you can't grab hold. And then I'd like for you to look back at me. And thank you, Mr. Witness, Miss Witness, for in fact walking out off the cliff to where you're standing out in the open air and nothing beneath you. And now, Mr. and Miss Witness, thank you so much for letting gravity have its natural course and effect and take you to an untimely demise at the bottom of the cliff. The strategy is to show them the cliff, have them confirm it's a cliff, invite them to walk off the cliff, and have them walk off the cliff feeling happy that you offered them the invitation to do so. And if you can handle those witnesses that way, then the jury's allowed to feel all the anger and upset and outrage that they should feel based on the degree of wrongdoing, and that will be focused on the defendant and not on you for how you're mistreating this poor person who's here being subjected to your asshole lawyer abuse. And that is the difference. By inserting yourself into the drama, you take the focus off the corporate wrongdoing and it becomes about you, and that's a guaranteed failure. So get yourself out of the way. Let it be about the defendant. Let it be about their wrongdoing. You are the facilitator of the story. You are, you're Virgil walking Dante through the levels of hell. You are not Dante walking through the levels of hell. Get yourself out of the middle of the story. Let the story be the story. Let the defendants do the things that are going to show the jury who they are, and do it all politely as you possibly can, as firmly as you need to be. If you have to ask the judge to direct the witness to answer a question, do so. But most of the time, if you are being a polite professional, asking fair questions, you won't get the chance to ask the judge to step in if they're being evasive, because the judge will let it go long enough for the jury to see that this person is going to be evasive, and then the judge will step in the first time and say, please answer the question directly. And then, when it happens again a few minutes later, the judge will jump in sooner and sooner until it is apparent that this witness is being forced to tell the truth, not that they're voluntarily telling the truth. And so then you've got sort of the best of both worlds. You've got the evasive, hostile, defensive witness who the court has to more or less get on to have them, tell the story. And by you keeping your cool, keeping your focus on them, on letting the story be told through the testimony rather than by your active interference, you keep yourself out of the center of it. Let the wrongdoing be the focus. Stay humble, stay under control, stay polite. You get what you need without doing anything that takes away from the story and doing anything that diminishes the wrongdoing your client has experienced. And it's the simplest way to identify it is killing them with kindness. You want them to feel like they have been treated as politely as they've ever been treated in their life. Even if what you got out of them utterly destroys the defendant's case. When they walk off the stand, you don't want them spitting at you, yelling at you, cussing you. You want them to have walked off the stand going, gee, he is so nice. Because you don't need yelling, screaming, abuse, table pounding, pomp and flair. You just need to ask the next question, detach emotion from it, let the testimony have the effect, and you will see your results go in the direction you want them to go. There's nothing that you can add to a trial to create drama and tension by your conduct. If you want the drama and tension to be focused on the defendants, then that has to be, you have to remove yourself so that you are not a distraction. And I think that's the most difficult thing that most lawyers struggle with. And I think that especially when you have righteous indignation and you want to pound that defendant into submission and you want to make sure that everybody understands how bad they are, it becomes easy emotionally to get yourself in the way. You want to win. You want them to suffer for how they've mistreated your client. And first of all, you're never going to make a corporation suffer. Second of all, if you can make them suffer, it's only by the size of the verdict. It's never by how you treat some poor bastard that's got to come testify because they've been elected to be the voice of the company. So if you want to punish them, if you want to hurt them, if you want to reach them, you have to withdraw from attention. You have to become the narrator, the guide to the story. And that involves your own humility, your own kindness, your own empathy, but then you have to also know when to be firm to make sure that you force the defendant to give actual answers and not filibuster with some made-up story that they'd like to tell. And that's the way that your demeanor has to carry for you to be successful when you're dealing with a direct of hostile witnesses. When you cut to your own witnesses, that rule of kindness applies to everyone that you're going to deal with as a witness. But before we get to your own witnesses, let's talk about those other categories of witnesses that you may bring to the stand, other corporate defendant employees, other fact witnesses, other experts. Same rules apply. Be the narrator, guide the story, require an answer, but do it all with kindness, politeness, but firm insistence that you get the actual answers and not a filibuster. When it comes time for your client to be on the stand, if you've done your job, you can more or less just confirm their experience, have them sort of tell what happened, and have them talk about, how they've been damaged and how it's impacted them, and let that lived experience come through the testimony, and you should have already thoroughly examined your own client way back at the very beginning. You should know extensively kind of what they lived through, and then over the course of working up the case, you have dug deeper and deeper and gotten more and more detail so that by the time they were deposed, they can tell the full story. And then by the time they get a trial, that story can live through your narration for your jury. And, by doing that, again, the emphasis is the story. How were your clients destroyed by the misconduct that you've just spent time laying out? How did that destroy your clients' lives, and how are they changed because of it? And then, of course, with your friends and family witnesses, what's your singular focus on there? I've never had one of those witnesses go beyond about 20 minutes. That was my questioning. A lot of them, they may only be on the stand to confirm one thing or to tell one anecdote about something they observed or what they saw happen to my client, just to make sure that everything's ironclad. So they're not on the stand long. If you're done it right, you could take 5 friends and family witnesses in an hour to 90 minutes. And, 5 is usually more than enough unless you have a truly exceptional case, when it can be There could be circumstances, but they would be rare, and it would be a big trial where you would need more than that. When you talk about, you know, you've gotten through putting on your complete case, you're able to rest, the defense calls up their witnesses, usually going to be their corporate rep, that they're going to try to put on their sanitized story that they've contrived that they think is going to cover up for what they've, or excuse what they've done. You know, when you handle those people in cross-examination, again, you want to be kind, you want to be polite, but you want to be firm. Make sure you get your answers. And, you know, normal rules apply to that type of cross-examination in the sense that you're asking leading questions that require yes or no's. And you're basically just pointing out that a couple of days earlier, when you had them on the stand, they were telling a different story. And you can do that by going into the details. Things are changed between the sanitized BS story the defense has made up and the actual facts, right? And if you've done your job right, again, you know, jury will have seen things like, oh, now they have this perfectly scripted story when their lawyer's asking them questions. But when Wooten had them on the stand the first time, man, they couldn't answer 90% of the questions he had. They were hem-hawing and ho-humming and making up excuses, and the judge was having to beat him over the head with a gavel to get straight answers. Jurors pick up on that. It's obvious that that's coached and rehearsed, and it's pretty easy to point that out. And then usually there are going to be stark and glaring contradictions, and you don't have to point out many of those. But as you do that, you'll have success. And once that's done, then you really should be at a point where the evidence closes and you're ready to move to the next phase of the case, which is about handling your closing arguments, resting your case, handling closing arguments, and then arguing damages. So we'll have another video that covers those things soon. We appreciate you taking time to spend time with us and talk about these issues. Look forward to the opportunity to share more with you in the future. If this video has been useful or helpful in any way, please, again, like and subscribe. And catch some other episodes that you find helpful and useful. Thanks again, and we look forward to sharing with you soon.